Hello everybody, Legally Naya here, and today I'm going to teach you about what a copyright is and why you should get it registered. First of all, a copyright is anything that you create, such as literary works, like a book or a script, dances, photographs, or even music, beats, lyrics, and it is automatically copyrighted upon creation when it is in a tangible physical medium. Now, the reason why you should register a copyright is because it gives you stronger legal protections to where you can automatically get statutory damages in certain circumstances and attorney's fees, as well as the fact that registering a copyright puts everybody on notice. So when somebody infringes, the court will automatically look at you as the inherent owner with specific rights, making it easier to prove in court and making it easier for you to get more monetary damages. Hello everybody, and welcome to a week in the life of an intellectual property legal intern. And if you haven't seen my part 1, go watch part 1. But guess what, you guys? Today I am doing a client meeting, and this is about a copyright case. It starts in literally like 20 minutes, so I just want to get comfortable and greet you guys, talk to you guys. I'm very excited to be a part of this client meeting. This is the client that I started their legal research for. They wanted to do one specific thing, and that wasn't legally allowed, so we and I found some alternatives. Today we're going to figure out if they go with those alternatives. We're going to describe to them what can be copyrighted and see where they're at and see if they have any concerns or anything they might add for information that maybe may make us be able to copyright what they originally wanted to copyright, but we will see. I'm just excited to be a part of this client meeting. I believe being punctual, but always early, because when you're early, you're settled down, you're ready to go, and you're ready to talk, and you're just in a calmer mood. So I'm about to go in the office to start getting ready for this meeting. And yeah, we're starting off the blog with a hit. We're starting off with the client meeting. Enter meeting 5 minutes early because it's good to be on time. Hi guys, you know what's going on? We have an update for you. Now, the client meeting was very fun. I love interacting with clients, and like I said, this was the first client I had that I actually worked on their case and got to meet. So that was very interesting. Our client was really laid back. He was cool, he was chill, and he was really there just to get information and understand. It's really hard to understand the law when, you didn't go to school for it. To us, especially as law students and lawyers, we could talk in legalese all day. We make sense to each other, but you start bringing out these terms and the person who was not in law is like, what does that mean? So, a lot of clients really just want to understand what's going on. Sometimes the law is not on their side and they'll be like, oh, I want to copyright this. And then you have to look at the law and be like, okay, now, the law doesn't guarantee that, but there's this angle, and sometimes it's not what the client wanted, but it's how they can get the most protection, so you have to keep that in mind. And that was the situation with this client. He wanted us to do something, and that was prohibited under copyright law. And I found another angle through legal research about how to copyright and protect at least aspects of what he wanted to do, and he's interested in that. And he just asked me a question about how he can perfect the new route he's going to take, since it's on him to redo it and come back. And I just gave him pointers. I looked at cases, and the cases don't really specify exactly what a person should do. It just says that they should have creative expression. So I gave him pointers based on how I see creative expression can be reached based on the cases, but they don't tell you what exactly creative expression is. All it just says is that procedures, ideas, and regular functions and discoveries and things like that are not copyrightable. For example, in the copyright case that I went over in one of my shorts with TikTok star Brooke Bellamy and Nagi Mahashi, where Nagi Mahashi accused Brooke Bellamy of stealing and using her recipes. Now the question is, was her recipes copyrightable? And basic stating of ingredients and mere facts is not copyrightable or copyright protected under copyright law. Now, you have to get creative as an attorney and as a legal intern and think, okay, if mere facts are not copyrightable, then what is? Creative works. Copyright explicitly protects creative expression through a physical, tangible medium, whether it's dramatic works. Literary works is books, scripts, musical works, sound recordings, the actual songwriter who wrote the lyrics, the person who sang the lyrics, the person who created the beat for the lyrics. So copyright is expression. So when I hear something like mere facts, for example, Brooke Bellamy and Nagi Mahashi, I would ask Nagi Mahashi, what did you just list the ingredients? Or was there anything narrative in your ingredients? Did you add personal elements? Did you create a story? Was it more than just stating facts? And if the answer was no, then Brooke Bellamy did not steal her recipe, because a recipe is just mere facts. And you cannot copyright mere facts. But if Brooke Bellamy took her personal and narrative and creative expressions with her recipe, then that would be copyright infringement. I hope that makes sense. So the thing with copyright law is some things are more black and white. For example, you wrote an original song, boom, that's copyrighted. But for example, if you want to do a recipe, well, is that copyrightable? The answer, it depends. And a lot of things you can make copyrightable with a different angle, with thinking creatively, and that's on you as the attorney, as the person doing the copyright work, for me as the legal intern, because that person's coming to you, they're like, okay, I'm a chef. For example, Nagi Mahashi, I want to make a cookbook recipe and I don't want anyone to steal my recipes. Well, this is what I would advise. Let's make your recipes so creative, so narrative, so deeply intertwined with creative works that if somebody tried to take your recipe, they were infringing on your creative aspects too. So you have to get creative as the legal intern, as the copyright, as intellectual property attorney, because the thing is with trademark law is more straightforward. Somebody has a business, they have a good or service, and you protect that good or service by making sure nobody else can have a brand name in that good or service. But when it comes to copyright law, some things are going to be more straightforward, like music and a songwriter's lyrics and a beat person's producer if it's original. But there's loopholes and there's things you have to do. For example, if somebody wants to copyright something that is not typically protected by copyright law, but there's an angle. And somebody might be like, no, I want to only copyright my recipes. And you would have to be like, well, you can't copyright your recipes, but if you're open to this idea, then this is as close as we can get it. And I still recommend doing that, because people are not creative when they infringe, when they steal your work. They're literally lazy stealers. They're going to take it verbatim. And if they take it verbatim like that, then guess what? Them taking your creative aspects, that's infringement. Even though your recipe itself is not protected under copyright, that is infringement. And they don't know the law 9 times out of 10. So you want to protect yourself the most you know how. So for me, as a future intellectual property attorney, some things we won't be able to fully protect 100%. But as long as you're open to the angle, to the closest way to protecting your idea, I feel like we can come to a middle ground. And it's all about your willingness and my ability to find another angle, to look at the law and to find an answer for you and bring you back something that you can protect. Now, some things you might not ever be able to protect, like if you're trying to copyright something like a list and you're like, nope, I want to copyright the list. Well, we can't do that. So help me help you. We gotta just come together, and that's why it's important to find a good intellectual property attorney, because one attorney could just look at that and look at what you're saying and be like, oh, you want to do ingredients? No, that's not copyrightable. But an attorney who thinks outside of the box, who has a creative vision, who could put themselves in the aspect of the cook, of the chef, of the cookbook author, of somebody who really wants to protect their ideas, can think about it and be like, well, okay, this is mere facts, but let's find another angle in storytelling, in your creative expression, because I know that copyright protects creative expression. So things like that is how copyright gets more in the weeds. And I actually really like this aspect because it makes me use my mind, and I have to be in the perspective of the book author, of the chef who wants to write a book, of the artist, and I have to think from their perspective and think, how can I look at their work and protect it? And like I said, not everything will be able to be protected. Sometimes you might want to protect 4 out of 4, and maybe we can only get 3 out of 4, but maybe we can make it in such a way that it still gives you strong rights. That's just another way to look at it. And that's why, like I said, important to find a good intellectual property attorney who's willing to think outside the box and do the work, which is why you should clearly come to Nia Chung in the future. And something else about creativity and thinking outside of the box is software. You can copyright a software code. Because copyright protects literary works, it will protect the numbers in your code, but it doesn't protect the function of the code itself. So say you create a software and you have a code, but we can't protect the software. We can't copyright the software under copyright law, but we can copyright the code. So therefore, if somebody uses your code to create the same software, the fact that they use those numbers that were copyrighted and protected is infringement. Even though we couldn't protect the software itself, we protected the code. So it's really about getting creative under copyright law, and the more angles, the more open your mind is, the more you could see from different perspectives and look for the nuance, look for the holes, the better as an IP attorney you will be. And not everybody can see that nuance. You might go to an attorney and they might be like, software, sorry, can't copyright that. But they're not looking at the angles. And that's why I'm glad at the firm I work with, because they get extremely creative. The attorney, supervising attorney, Attorney Randy, she was an engineer before she was an attorney for a long time, and she has that creative mind. I have a creative mind too, and I just feel like we work well together because we don't look for no for an answer. We look for an angle, and that's one thing she's teaching me at her firm, is that we find another way. And I love that. I love people who don't give up, who work hard, and who really fight for their clients, and she fights for her clients, and so will I in the future. So thank you, Attorney Randy, for showing me that drive, for showing me that determination, for showing me to always find another angle. So that's why I'm an IP, because I love that stuff, and as you can see, I'm a content creator, so I like to think outside the box too. But anyways, guys, what we have to do next is a copyright block, and I'm going to do the research first, and then I'm going to tell you what that's about so I can stop yapping. See you guys later. Commercial break. Just kidding. Hello guys, so I've mainly got through my copyright first rough draft. Of course I have to go back and fix the grammar and everything, but I just want to say that I really love writing blog articles because it helps me learn the law and stay current on current issues. So I feel like I'll do this in the future whenever I have my own firm one day, but literally it helps me learn the law so much more. So I'm thankful whenever Attorney Randy finds me an issue to talk about, or I find my own, because now I know more about trademark law. Now I know about copyright law. Now I know about the Copyright Office and its role, and it just really helps me learn more on top of the practical side. So I'm very thankful that she does these blog posts, and I'm basically about to be done. I'm summarizing right now, and I'm gonna go back later and keep tweaking it, but I've already done what I needed to do for today. And yeah, the copyright.gov office website has videos teaching you copyright law and what you should know about fair use, and even works made for hire, as well as copyright for writers, copyright for visual artists, copyright and collaboration, and so many other things. Look what musicians need to know about copyright. In addition, they have a YouTube channel where they have more videos at the US Copyright Office, more videos going into copyright law and just history about it, and maybe things you might find interesting or what you should know. Okay, you guys, I hope that clip really helps whoever needs to see it, whether you're a possible client, somebody in the creative world, or somebody who's a law student and just wants to know more about copyright law. I went through so many of those videos when I first started my internship to make sure I understood what copyright law was, what things it protects, what are the inherent rights of a copyright holder, and it really helped me learn a lot. So I hope it helps you use it and get ahead of the game, especially if you're a law student and you want to know more. And for a possible future client, use it so that when you come to me in the future, you have an idea of what you can protect and what it is, and you have your own idea, background, and understanding about copyright law. It's important just as much for a possible client to know about the law as well as the attorney, because how will somebody know that they can file something or register something or sue somebody if they don't even know it exists and they don't know the law? So it's important for all parties to be informed, which is why I try to educate whoever just a little bit on my channel. But about my copyright blog, what I was saying earlier is so real, you guys. Honestly, I feel like I get a lot of my research, a lot of my learning from doing blog posts. I'm learning why in a current court case that the judge has ordered and ruled on that pertains to AI, they did not hold infringers liable, which is Meta, Facebook, against book authors who sued them because they used some of their material to train their AI. Ultimately, the reason why the court ruled on that is because Meta used the material not to resell or copy the books, but to train their AI, and that was considered to be transformative and fair under the fair use doctrine, which is a defense. But the reason that the authors mainly and really lost is because of the fact that they did not show harm to their market. They didn't have any actual concrete proof or evidence to show how they were impacted financially. But if they would have came there and said and shown proof of the damage done to their market, to their books, then the court would have most likely ruled with them, because the judge in his opinion literally said this, and I'm going to read from the actual order. The upshot is that in many circumstances, it will be illegal to copy copyright-protected works to train generative AI models without permission, because Meta did it without permission, which means that the companies, to avoid liability for copyright infringement, will generally need to pay copyright holders for the right to use their materials. So therefore, the court in this case is saying, if somebody training their AI models uses your work without permission, then they will be liable. But another thing that I pulled from this case was they acknowledged that Meta used the book author's works, and so did Meta in their case. But where the plaintiffs went wrong is they had no proof of how they were financially impacted in their market. And so this tells me that even if somebody infringes and uses your materials to train AI, you must have proof of harm. And that evidence is going to push you over for the court to whatever with you, because the judge in this case is literally saying how this should not be allowed. But he's also saying that he had a rule on the merits and the facts of the case, and in this case, the plaintiffs did not have enough evidence. So basically, this tells me that the court, or at least in this decision, wanted to protect the right of the copyright holders, but the copyright holders needed evidence and proof, not just speculative damages, because a judge ultimately does have to rule on facts in your specific case. And luckily, this case is only limited to these people, but it still gives you an idea of what to look for. And unfortunately for them, I wish they had more. But now we know for the future. And to be fair, AI is new, AI is transforming, AI is coming faster than anticipated, and AI is now here. So the courts are just now ruling on these things, and a lot of things attorneys didn't know until cases like this come out to help guide lawyers and future attorneys and attorneys on what the decisions are. So if you're an attorney, if you're a legal intern, if you're working in IP, it is very important to follow all of these AI decisions right now and make sure that the court is not ruling against copyright holders. That way you can protect your clients and you can know the law. And that way, if your client does need to sue, you know what they need in order to go against an infringer like Meta. Because what this tells me, in my opinion, is that Meta could have lost and owed these plaintiffs if the plaintiffs would have had strong documented evidence of their harm, but they didn't. And we can't blame their attorneys 100%, or the authors. They might have not had that. And the attorneys might have not known that they needed more proof until this decision, because unfortunately, we are living in the times of first decisions when it comes to AI. So work with your attorneys, work with people in the IP world, because this is unfolding for both the legal side and clients and copyright holders and everybody with AI. So what I will say is, as a copyright holder, make sure to have documentation of everything you do, everything you have, dates, extensive documentation for attorneys. Make sure you keep up with the law, as well as legal interns and intellectual property. The law is evolving and technology seems to always be faster than anything, and we have to figure out how to catch that, and the courts are trying to. But yeah, I learned a lot. The opinion was literally 40 pages, and it was very in detail. So if you want to read that opinion, I'll leave it in my description below. But in about 40 minutes, I'm also going to have my meeting with attorney Randy. Normally in these meetings, we do a weekly update. I tell her how I'm doing. She might give me more work. Maybe I'll give her some questions. And yeah, so welcome to today, and stay tuned for our meeting. And after that, I don't know what I'm going to do. But I do have my rough draft for my copyright blog. I need to keep fine tuning it. That's what I do before I really upload it and submit it for my final rough draft to the firm. And I have gotten a patent inquiry. I've answered 2 of them already. The 3rd one, I feel like I need more information because the question was about international. And I'm like, well, which system is the international? I didn't get to see the actual file of the case. So I feel like I need that information to do more. And sometimes you just have to ask a question if you need more. They know that patent law is not something I primarily focus in, but I'm open to learning always, and so I need more. And they will easily give that to me and maybe even explain more during our meeting today. So yeah, but see you guys soon.
Be a rapper, but don't gotta change. Stuck in my waist, so I'm loving my beams. Like 1 million views in a day. There's so many ways to get paid. I tried dipping, he begged me to stay. Babe, I'm not staying, I just wanna play. In the party, he just wanna rump. Big boobs in the bus, they plump. She a baddie, she knows she a 10. She a baddie with her baddie friend. They like ice, how you always stay hot. Oh, they mad cause I keep making bops. Oh, she mad cause I'm taking her spot. If I was bitches,
Hello everybody, welcome to the recap. Please excuse my voice, I'm losing it just a little bit because I went out and had a good time with my friends and I already got a raspy voice. But let's talk about what we did this week. This week we had our client meeting, and then after that I had to go back and find legal research into the copyright blog. As you see, we talked about that, and just to clarify, the plaintiffs were asserting and basically suing for copyright infringement, but Meta used the defense of fair use. And fair use is a defense to copyright infringement. And if fair use is granted and acknowledged by the court, then basically it's saying, well, they didn't infringe. It was fair use, meaning they were allowed to use your work for those purposes, and the court ruled in favor of them. I feel like because when the Meta AI couldn't produce over 50 words from any of the authors, and that was for prong 3 of the fair use, how much did a person take? For real, even though they probably took it all, the AI could only regurgitate only 50 words back for all authors. It was like they barely used the information. Then the plaintiffs didn't really show their market had a strong possibility or an actual possibility or just an objective possibility of being impacted, and the judge really said how they argued the wrong claims. They argued 2 theories, and the judge was saying that the theory should have been more market dilution and how the AI using their copyrighted work can impact them in the market, and they didn't argue that. So that's how the court decided on that. The question would be, is it still fair to use fair use as a defense to human copyrighted material? Because AI is a different beast, and maybe they should create a different test, because maybe AI is going to keep winning in favor. Or maybe you may agree and say, well, it was for a different use, it was just training, and it wasn't creating the same books to where that shouldn't be considered copyright. So let me know in the comments where you stand. Next, I did patent inquiries, even though I didn't talk about that for real. I had 3 different inquiries. It was interesting. I learned a lot about continuation in part, patent terms, and priority dates. When can you claim the priority date of a patent to show you were the first inventor? Can you claim the provisional patent, or does it have to be the non-provisional patent? Let's give you a second. Did you come up with it? If you guessed correctly, you can do your priority date from a provisional patent. So keep that in mind, because provisional patents are always filed before non-provisional patents, just so somebody can get their invention out there and secure the rights to be the first to file. And you can date back your patent all the way to the provisional. So you learned something new. Next, I have a lot coming up that I've gotten for my meeting. I have another blog. I have to start calculating patent expiration dates, doing the math, making sure everything's correct from the past to the present to the future. And something else I have to do is write down all office actions for a trademark denial and have every remedial action explaining what to do. So I'm gonna learn a lot from that, but I'm getting deeper into intellectual property and trademark law, and it's so much you have to do for real. Honestly guys, it's so much research, it's a lot of filing, it's a lot of back and forth, it's a lot of waiting on your client. The reason I couldn't file a copyright application in this video is because this is just a reality about IP and copyright. You see, we went to our client, they had to change something, now they need to brainstorm about how to change it, and until they do that, then they have to come back, then you'll be able to file the copyright. So it's a lot of waiting on your clients, a lot of waiting on the US Patent and Trademark Office, it's a lot of waiting on the Copyright Office, and this is just how it goes. And yeah, legally Naya, legally Naya. Come to me in the future. All my future clients, we locked in. Legally Naya, legally Naya, legally Naya, legally Naya. Anyways, don't forget to give this video a thumbs up, like, comment, and subscribe. Let's get this video to 100 likes. Drop a comment if you learned something. I want to know. See you guys later! Hello everybody, Legally Naya here, and I'm going to explain to you what the difference is between a copyright and a trademark. A copyright protects your creative expressions once you put it in a physical medium like music, books, a script, photographs. And a trademark protects your brand's identity, like your name and the service of goods you sell with it. It is possible to have both trademarks and copyrights at the same time. But know that trademark is more brand protection and protecting your services or goods, and copyright is more of protecting your creative works and your creative expressions.
You got dude.